the orders of others. Long ago, Cicero described an answer to this central question about the nature of power. He thought there were three possible ways to assure the obedience of those who live in a state. 1. The fear of punishment. 2. The hope of rewards or particular benefits. And 3. The perception that the state is a just one. This last way, justice, was to convince people that those who govern deserve obedience. Whether Cicero's view does or does not apply in general to government, it certainly applies to the U.S. Supreme Court. The court's ability to punish or to provide rewards or benefits is limited. Its ability to act justly, at least in my view, does play a major role in obtaining the public's respect and consequent obedience. The court's history illustrates how that is so. A few examples will help support this point of view. In considering those examples, it is important to keep in mind how the law provides the court with legal power. That power has its principal source in the U.S. Constitution, as well as in the views of those who wrote it. The Constitution is a brief document. It has 7 articles and 27 amendments. It creates a representative federal democracy with a separation of governmental powers, both horizontal, legislative, executive, judicial, and vertical, state and federal, equality of individuals before the law, protection of fundamental rights, and a guarantee of the rule of law. The Constitution's framers had every right to admire their creation. But, as Alexander Hamilton points out in Federalist 78, one branch of government must have authority to assure that the other branches act within the limits set by the Constitution. Otherwise, the document will have little effect. The framers might as well have hung it on the walls of a museum. Which branch will have the authority to determine what limits the Constitution sets forth and when a branch has exceeded them? The executive branch, namely the President? Is there not a risk that the President would simply decide that whatever action he or she takes is consistent with the Constitution? What about Congress? Its members are popularly elected. They likely understand popularity. What would happen when, say, those entitled to constitutional protections are not popular? The Constitution, indeed law in general, applies to those who are not popular, just as it applies to those who are popular. Can Congress be trusted to protect the unpopular? The third branch, the judiciary, remains. Very good, Hamilton might have thought. Judges understand law. They are unlikely to become too powerful, for they lack the power of purse and of sword. Hence, the judicial branch and the Supreme Court in particular should have the last word. The majority of the other framers agreed with Hamilton. But the acceptance of this view was not inevitable, nor was it to come without a long struggle. Unlike Hamilton, Thomas Jefferson was unwilling to give judges the ultimate power to resolve constitutional and statutory conflicts, particularly at a time of heightened partisanship when the judiciary was perceived as favoring Jefferson's political opponents, the Federalists. Indeed, Jefferson once wrote, "Each of the 3 departments has equally the right to decide for itself what is its duty under the Constitution without any regard to what the others may have decided for themselves under a similar question." As far as Jefferson was concerned, the less powerful the Supreme Court, the better. It was Hamilton's view that Chief Justice John Marshall and the Supreme Court adopted in the famous 1803 case Marbury v. Madison. The case arose at the time of the Midnight Judges. John Adams, a Federalist, had just lost the presidential election to Jefferson, a Democratic Republican, now the Democratic Party. Adams quickly nominated several judges. The Senate, within a few days, confirmed them. All that remained was for Adams to deliver their commissions in time, that is, before his term as president expired. Adams failed to deliver William Marbury's commission.